So then it really boils down then, to the asset test. And the asset test, I believe in Idaho, you can have technically only $2,000 worth of assets. But of course, similarly, there's a lot of detail that goes into that calculation. And there's countable assets, non-countable assets. You have different rules depending on whether you're married. The first thing I was hoping you could touch on is how does that process work if I'm going to a nursing home and I'm married? What can my spouse keep?
Okay, so that's as you mentioned, the resources, the assets are really the biggest issue in kind of planning and trying to get Medicaid eligibility, and what we deal with primarily. The resources for the spouse who's at home, what we call the community spouse, is dependent on the amount of the resources. So we have to do what's called a resource assessment that kind of sets the value of those resources. And under the Idaho rules, there's a minimum amount and there's a maximum amount. I'm not sure I can tell you off the top of my head those numbers, but the minimum's about $25,000 or $26,000.
Right.
And if the countable resources, again, we're talking countable resources, are under that 25 plus 2,000, then the person's eligible, and so that spouse can essentially keep that 25,000 or whatever. If it's more than that, then it's generally a rule of half. They keep half of the resources, of the countable resources, up to a maximum of 129,000. So, in other words, if they had 200,000, then they would only be able to keep 100,000. But if they're at 250, then they'd only keep the 129,000. So, that's kind of the way that rule works for the community spouse.
Okay. And then, I also want to touch on some of the major assets that people own that commonly and sort of how they're treated. Many of them also, get relatively favorable treatment. The first one that comes to mind is your home. And I was just wondering if you could just go into, how is real estate treated for Medicaid purposes? When does it count? When doesn't it? Is there a difference between my personal residence and a vacation home, and so on and so forth?
Yeah, and the personal residence is excluded as a resource, generally speaking, and that's really dependent on if there's a spouse living in the home, or technically a minor child or a disabled child could be living in the home, and that excludes it. And it really excludes it no matter what the value is. If it's a single individual who's needing Medicaid, then the home can be excluded based on a subjective intent to return to that home, which is really simple. It just means if they were, if something happened, miracle, and they could go home, then that's where they would go. So that excludes the home as well. And there is a limit, because if it's over, it only excludes it up to $750,000, which in Idaho, that's not, I've never had that as a problem because the real estate isn't that high. It's heading that direction, but it's not that
not there yet.
So as a general rule, I haven't run into that as much of a problem. One of the nuances in Idaho, and I'm not sure that I've seen it anywhere else. Well, of course, I don't know all the other states, but there's a rule in Idaho that says if the home is in a revocable living trust, which we know that's often a way that people use as a planning tool, estate planning. But if it's in a revocable living trust, then it counts as a resource and it's not excluded. So it causes, there's many times that we end up having, and we can just pull the house out of the trust and that makes them eligible. And technically we can put it back in. There's some issues with putting it back in and whether we change the trust or do some other things if it's a community spouse. But that's one of those things. And it's just kind of this, because Idaho doesn't really like trust very much and they don't like it being there, and it's kind of an issue. They put this rule in. And so that is kind of a problem once in a while that we have to deal with but again, it's not too difficult because we can deed it out of the trust and put it back in or do something along that line once eligibility is established. So, and then with other real estate, any other real estate is a countable resource, but a lot of times what I find for instance, if it's rental property, because that's income producing property and it's in current use, then that's excluded as a resource. Now, the rental income counts as income, so then that affects that income part of it, but it can exclude that resource in that way. And the other option, there's kind of some tricks with this, and I'm not sure how much it kind of gets a little complicated because it's dealing with who owns it and so forth. But sometimes just listing that real property for sale will also exclude it, and we can get what's called, and the name just went right out of my mind, I apologize, but conditional benefits. And so it's kind of conditional because it's listed for sale. But a lot of times what happens is that property, I mean, right now the market is such that things are selling really fast, but sometimes we'll have like a cabin or something that's, and those, they're not selling that fast. So it might be on the market for a while. A lot of times we can then sort of transfer that to the community spouse, and then if it sells, we can keep those resources. So there's some options there, just dealing with the real estate once in a while. Sometimes it's a little more complicated and the family wants to keep the cabin, and trying to figure out how to make that work isn't always as easy, but it is possible once in some situations.
You know, the next asset beyond a personal residence that most people seem to have these days is some type of a retirement account, and whether it's a 401k or an IRA or a 403b. You know, how are these accounts treated in Idaho? Are these countable or non-countable, and are there exceptions? And how does that work?
In Idaho, and this is, well, it's been a few years back, because for some time when I was practicing earlier on, they were all counted as a resource, and sometimes it was a real issue dealing with those IRAs and how, you know, because of the tax consequences of pulling it out.
Right.
But then they modified that rule, and so the retirement accounts, IRAs, et cetera, that are owned by the community spouse are excluded no matter what. So it doesn't matter what they have; those are excluded and not counted as a resource. For the person who needs nursing home level or nursing home care or long-term care, the IRA or retirement plan is excluded only if they're taking their minimum distributions. Now, technically, that's that required minimum distribution, which you don't have to take until you're age 72 now. But essentially, what happens if they're under age 72, we essentially just have to take a minimum distribution. So we usually just extrapolate back and figure out what it would be at that age and just take that amount out each month. And of course, that's income, that's counted as income to them. And so that again affects that income test, but that does exclude them. And it really just excludes it between 59 and a half and 72, because under most retirement plans, you don't have a right to take it out penalty free until you're 59 and a half. And so I've only had this happen like once, I think, in my career. I had someone who was under 59 and a half. And so in those situations, it is countable. And so we have to work out some ways to try to, you know, deal with that in that situation, but that doesn't happen very often. So, and to me, those retirement plans are sort of a catch-22, because anything that comes out of them is counted as income. And so it sort of ties the IRA up. It is excluded as a resource, but in a way it sort of ties it up, because you really, for instance, the community spouse, and sometimes that's part of the issue. Like I have many times with a community spouse, they have this distribution they need to take, but we push it off and only take it in December, so that it only counts as income the 1 month that they receive it. And that actually is more beneficial to them than receiving it every month. Whereas with the institutional spouse, most of the time we take it every month just because it's easier to calculate, and they've got to use it because it's counted as income to them and so forth. So kind of there's a few planning tricks a little bit with how we use those, but it is sometimes it's kind of a difficult situation, because a lot of them, there's not, it's assets sitting there that they can't use really to do much else. So
I guess it sounds like, you know, it gets somewhat favorable treatment, but from a liquidity perspective, it's not necessarily stuffing an IRA full of cash isn't necessarily the best planning strategy either.
Right.
And then, you know, and other you know, financial instruments that you see are are life insurance, annuities. With life insurance, it seems to boil down to, you sort of have, they all boil down to these two different types. You have those with cash value, like whole life or universal life insurance, and then you have policies that don't have any cash value, like term life insurance, which is actually probably more common now. Are these given different treatment, and is one more favorable than the other from a Medicaid asset test perspective?
Well, from the asset test, obviously the term insurance, because it has no cash value, it doesn't have any effect whatsoever on it. The one issue that you kind of run into with term insurance is you're paying premiums on it, and because of, especially for a single person, their income is now having to go towards their long-term care under the Medicaid rules, under the share of cost, and so they really don't have money to pay that premium. But there's some advantages sometimes to have the children or whatever pay the, it kind of depends on the policy, and that's always looking at what is the death benefit, is it worth it or not, to have them pay that. Because if and this is kind of skipping to the estate recovery, but estate recovery under the rules, if life insurance goes to a named beneficiary, then it doesn't, then estate recovery doesn't have a claim against it. So sometimes using that life insurance and paying those premiums may be a benefit to the children because they may get that policy if they're named as the beneficiaries. So that's kind of skipping to a different issue. But the other, when we deal with policies that have cash value, that's a little more difficult because the cash value counts as a resource. So it's always looking at those policies and trying to determine, is that policy worth keeping, number one? What's the difference between the death benefit and the cash value? Is it better to just cash it out and use that for something? There's been times when we will borrow the cash value. And again, I find with life insurance policies, there's so many different policies and different terms and how they work and what that it is kind of complicated. But if there is that cash, sometimes we can borrow that cash value and use that resource somehow. And let's say the death benefit is quite a bit higher, then because it now has zero value, maybe transfer that policy to a child to own, who can then pay the premiums, but then have the benefit of that death benefit too. So, there's some, and that's just kind of one little option, but it's sometimes trying to deal with that. There is some exceptions. For instance, if the face, I may not say this exactly right, but if the face value is $1,500 or less, then the life insurance is excluded, even if it has cash value. But that's, if it's only have $1,500 face value, usually the cash value isn't very high either. So usually.
Right.